Right. Next we have Delegate Aird on HB 5099. She's there. Welcome, Delegate Aird.
All right, can you all hear me?
Yes, we can. I can.
Okay, good evening, Madam Chair and members of the committee. Again, you should have before you House Bill 5099 regarding the prohibition of no-knock warrants. Madam Chair and members of the committee, this legislation would prohibit any law enforcement officer from seeking, executing, or participating in the execution of a no-knock warrant. It would require that any officer should provide a copy of the search warrant to the person to be searched. The bill requires law enforcement to also provide notice of his identity and authority. And it would make it so that any evidence obtained from a search warrant in violation of this would not be admitted into evidence for any prosecution. Madam Chair and members of the committee, I bring this legislation before you for a number of reasons. Many believe that today's legislation is political in nature and that it's solely about the tragic death that occurred now 166 days ago, the death of Breonna Taylor, for whom we continue to hope will receive justice. And while as a Black woman, as a Black mother, my heart breaks for the loss of Breonna Taylor, my heart breaks for the loss of life for anyone for that matter. But the truth is, this tragedy only allowed the resurfacing of a controversial practice to be reevaluated once again. As many of you know, the history of the no-knock warrant is that it came into practice under the Nixon administration in an effort to crack down on the drug issues they were experiencing at that time. There was widespread controversy even then that led to its repeal, but later then returned in the 80s as police departments ramped up their militarization tactics. What we knew then is what we know now, which is simply that in the use of no-knock search warrants, these door-busting techniques create a greater risk to residents and the officers with this kind of search that far outweighs any benefit that can be gained. After numerous conversations with law enforcement, advocates, prosecutors, I understand how this technique is often perceived as a tool that should not be eliminated. But the very nature of surprise, entering someone's home, which I'm sure you would all agree, your home is your castle, often late at night or early in the morning, heightens the risk of violence. And the added prevalence of gun ownership, especially here in the Commonwealth, only further raises the risk. Madam Chair, I want to be clear that this legislation is not about hindering law enforcement or taking a tool away from them. This is about better protecting both our law enforcement officers and all that might come in contact with them, especially in our Black and Brown communities. The legislation does not change that in an emergency situation that might require swift action to prevent imminent danger or to life or serious damage to property or to forestall the imminent escape of a suspect. None of this would prevent our law enforcement officers from doing their job to the fullest extent. Because, Madam Chair, as you know, and members of this committee knows, exigent circumstances are exceptions to the general requirement of a warrant under the Fourth Amendment search and seizure, which I am confident will continue to be the case with the passage of this bill. Right now, Virginia Code is silent on the specific use of no-knock warrants. Its use isn't consistently applied, and very little data is centrally available to demonstrate its application here in the Commonwealth. In addition, some have suggested perhaps approval with the use of the warrant by a judge would provide guardrails for its application. But from the data that is available, when urban police departments were assessed for its use, it was determined that judges very rarely reject the use of this warrant when requested, which ultimately does nothing to limit its use to only the most necessary circumstances. As it further relates to use, Madam Chair, national studies reflect that when the no-knock warrant is used, it is disproportionately applied in Black and Brown communities in search of marijuana. Madam Chair, the police chief of our fifth largest county, Chesterfield County, which is in my district, Police Chief Jeffrey Katz, who could not be here today because of scheduling conflict, shared with both me and members of the Chesterfield delegation publicly that he is in full support of the ban. He reiterated the risk to law enforcement, specifically with this search warrant, and is confident that they can continue to do their job with a ban fully in place. As we continue to strive this session to achieve racial justice and equity by right-sizing our practices and processes in polices, I assure you that passing this bill would add to accomplishing that. And in closing, Madam Chair and members of the committee, I recognize the tremendous sacrifice our law enforcement officers make daily, and for that, I am so grateful. But we cannot pretend that there are not abuses. We cannot pretend that there are not racial injustices inherent within our system. And we cannot ignore the prevalent danger to all involved with the use of this search warrant. And Madam Chair, knowledge that these searches have gone wrong and that they have resulted in the loss of life, even if just one life, which we know is not the case, that should be more than enough to have us do this differently. And by doing this differently with this legislation, I know it will support law enforcement too. This measure will better protect them and all that may come in contact with them. So I hope that you will support the bill. Thank you, Madam Chair and members of the committee.
Thank you, Delegate Aird. I'll first go to our guests who have some testimony, and then I'll go to our members. First is Dominique Martin.
Good afternoon, Madam Chair, members of the committee. I'm pretty much echoing the sentiments just laid out by the patron that these no-knock warrants are a vestige of the war on drugs and have proven to be inherently dangerous both for citizens and for law enforcement. And this has been most recently evidenced by the death of Breonna Taylor. Last month in committee, Sheriff Gabe Morgan also testified to another point the patron made in that law enforcement believes that they can continue to adequately perform their duties without the use of this tactic. And so we think it'd be a wise move to support this bill and end the use of this tactic and avoid the risk that inherently comes with it. So with that, thank you very much.
Thank you. Next is Valerie Slater.
Thank you, Madam Chair. I will just echo what the patron has already said and what Dominique Martin has already said, and let you know that the Virginia Coalition to Transform Policing and Rise for Youth both support this bill, and we ask that you please also support this measure.
Thank you. Wayne Huggins from the Virginia Police Association.
Thank you, Madam Chair. My testimony could be characterized more as reassurance than anything. This is a technique that is used extremely rarely, at least on the part of the state police. In fact, I was going back searching my memory during my 6 years as superintendent of the state police. I can't recall an occasion where we ever used a no-knock warrant. And I think, at least in the case of the state police, for our folks, the only time that we would ever consider using such a technique is if we felt there was a life in jeopardy. So having said that, again, just to reassure the committee, this is a technique that is used extremely, extremely rarely, and only in the case of a life-threatening situation. Thank you.
I believe that's it for the public. Shapiro, are you with us?
Yes, Madam Chair.
Yes, welcome.
Thank you. Good afternoon, Madam Chair and members of the committee. From Justice Forward, Virginia, I'm the legislative director there, and I'm also a public defender, so I practice criminal law and see the effect of these warrants on the ground. We support this bill and Delegate Aird in her pursuit to try to get rid of no-knock warrants. I think it's important for all of us to really take down what that term means. A no-knock warrant means that the police, without notifying the occupant of who they are, without notifying the occupant that they are even there, are allowed to just barge into someone's home. These are often done overnight when people are sleeping. As some of the other witnesses have testified, this actually endangers the police and endangers the occupants when people are entering into their own home. The use of no-knock warrants, as Delegate Aird mentioned, came up with the war on drugs. The war on drugs, which was a failure by most metrics, and that failure is only amplified by the racial implications of its enforcement. HB 5099 seeks to get rid of the use of these warrants that don't require the police to even announce they're present. It's important to note that Virginia has never actually even codified the allowance of such warrants. It's actually only done by case law. And likewise, the code does not prohibit them. But because it is not codified, there are no regulations, there are no parameters, there are no rules, standards, or exigency requirements. It's simply up to the enforcing officer to decide if that's what plan they want to pursue. This bill is important both for officer safety, as I mentioned, and for the safety of the people in our own home. So they eliminate the ability for police to barge into someone's home unannounced, and to eliminate the possibility of the historic disparate use of such no-knock warrants. And therefore, Justice Ford supports this bill.
Right, thank you so much. I see Delegate Campbell and then Delegate Mullen.
Yes, thank you, Madam Chair. The use of no-knock search warrants in Virginia has gotten very limited. And basically, like Wayne Huggins said, the only time the state police actually use it is to protect life. And 2 years ago, we had a situation where the state police knew that the subject that they had the warrant for had made threats against law enforcement, and he intended to kill anybody that come after him. They went to arrest him, and one of the troopers got killed. I'm sure y'all might remember that. We were in session. Had this person known that the state police were outside with an arrest warrant, he would have had opportunity to better arm himself and to take cover, and he could possibly kill more than one police officer. Now, if there is someone who has a problem with this, I think that we should look at putting an exception in it to where that if the police have legitimate evidence that a person has made threats against them to kill them, and in the case I just mentioned, this gentleman was a convicted felon and he had said he wasn't going back to jail. But you know, if we put an exception in there to carve this out so that we can protect the police officers against people like this. And that's really all I'm asking for, is let's put something in there if we intend to pass this to protect the police officers in situations to where they have legitimate evidence given to a judge and he issues the no-knock warrant.
Madam Chair, may I respond?
Yes, Delegate Aird.
Thank you, Madam Chair, and thank you, Delegate, for those comments. I heard you say a few things. I heard you ask for perhaps a carve out that speaks to certain types of dangerous circumstances. And I heard you mention perhaps having a judge's approval. And I would just reiterate the fact that it is my understanding that in those dangerous circumstances, what are considered to be exigent, that would not prohibit law enforcement from continuing to perform their duty safely and as you have described. I would also ask that I do believe it's great to hear that the Virginia State Police has only executed the use of this warrant in very limited circumstances to date. But what I also know in my various conversations with law enforcement across the state is that that is not the case for local departments. And I also understand that it is not applied uniformly as it relates to situations. And so the Virginia State Police is one law enforcement entity. And I do believe that the fact that they have only used it in limited circumstances, that most likely they can continue to do their job as other departments can, utilizing other tools and pursuing incidents that are of the most dangerous circumstances as they need to. And as it pertains to a judge's approval, I would just reiterate that my research reflects the fact that when urban police departments have been assessed for the use of the warrant, judges were far less likely to ever reject this request. And ultimately, that does very little to add guardrails to ensure that the use of this warrant is only in the absolute necessary of circumstances. Thank you, Madam Chair.
Thank you, Delegate Aird. Delegate Mullen.
Madam Chair, I honestly, Delegate Aird just dropped some fire there, and I don't want to repeat anything that she already said, so I just agree with what she said.
I got Delegate Levine and then Delegate Heretic.
Thank you, Madam Chair. I agree with everything that Delegate Aird said. I would add one more point that would hopefully allay Delegate Campbell's concerns. He talked about an arrest warrant. This bill doesn't affect arrest warrants. These are only search warrants. This isn't an attempt to get someone who's dangerous and arrest them, but to search for evidence, and it doesn't affect arrest warrants. Now, maybe there should be no knock arrest warrant. I don't know, or not, but whatever it is, that's not this bill. So hopefully that will allay Delegate Campbell's concern. Thank you, Madam Chair.
Delegate Heretic, then Delegate Watts.
Thank you, Madam Chair. In response to the patron, I understand and I appreciate the motivation behind this bill. We've seen cases like Breonna Taylor where horrific situations have been created by no-knock warrants. But I also understand, having a law enforcement background myself, that there are those rare and compelling instances where a no-knock warrant really is necessary to protect life. I think if there were a carve-out in this bill to require a circuit judge at a heightened standard of evidence to approve this warrant, I would certainly agree with this, but I cannot support any bill that creates a blanket prohibition on no-knock warrants. I think that it does not fairly characterize the law Fourth Amendment. I think it doesn't understand exactly how police have to work in certain circumstances. And I think legislation like this, while well-intended and certainly responsive to some horrific situations that we've seen around the nation, don't reflect the discretion that we put in, the faith that we put in Virginia judges. And for that reason, I must respectfully oppose the bill as written.
Thank you. Delegate Watts. Oh, you're on mute.
Thank you, Madam Chairman. Let me approach it this way. On line 92, I would propose that we strike the words after officer shall, strike the words read and. Motion.
Madam Chair, I would consider that a friendly amendment.
All right. Is there a second?
Second.
All right. All in favor of that amendment, say aye.
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 Apologize. I'm sorry. I lost it there for a second. What line number are we amending?
Line 92, following enforcement officer shall, strike the words read and.
Thank
you. The effect of the amendment is that the officer does not have to read the warrant.
Thank you, Madam Chair. I apologize. I was moving slowly.
Well, I move to.
You know what? Wait, hold on. I'm sorry. May I? And I know we've already voted on this, so I just want to make sure for those who cannot read, are we now, council, are we now creating an issue for those who are not able to read?
Madam Chairman, in my reading of this, I don't think it, because it's not shall read the warrant before they make entry, it's shall read it before they make the search. So they can read the warrant before they make the search. They can make entry, control the scene, then they can read the warrant and give a copy of the search warrant to them. I was looking at it because I'm 99% sure that there's somewhere else in the statute that requires them already to leave a copy of the search warrant with the person to be searched. So I'm not sure it needs to be said again, although I can't locate it this second. But the reading part of it is something that's different. But again, I don't think it slows down the process because they are making entry, controlling the scene, and then before they can search, because it says prior to undertaking any search or seizure, then they have to read it and give a copy to them.
Great, thank you. Thank you. And it's already been adopted. So,
Madam Chair, I'm actually persuaded by counsel. Unless there's any other explanation, I would move, having voted in the majority by which we approve the amendment, that we reconsider, given that the officer can still secure the scene. And so I guess I don't see the need for the amendment anymore.
Speaking to,
yes, please, Delegate Watts.
as I heard Council Mutnick, I had that same concern, because how does secure the scene differ from search, where you are moving throughout the residence? You are restraining individuals who might destroy evidence. I really don't know how that differs from searching. And it is, in fact, my concern that while the officer is, under the way I read it, prior to a search, any movement through the residence, that in reading the warrant, you were giving ample time for evidence to be destroyed. And this is where I thought the actual reading of the warrant was excessive, as opposed to giving any occupant the warrant.
I'll withdraw my motion. I'm agnostic. I'll leave it to the will of the others.
Counsel, I'm sorry. I just want to make sure I understand the way the law is now, the way it is drafted now before the amendment.
Madam Chair, in answering,
it would be read and given a copy, and as amended, there is no reading. It's just given a copy and a search.
Mm-hmm. And I think that the way that the law is set up in Fourth Amendment jurisprudence is that officers, before undertaking a search, even if they don't have a search warrant, are able to enter a scene and secure the scene in order to even go get a search warrant. And so there is the law has set up two separate actions of entering a scene and securing it, and then the actual search that occurs. And so, that's in a lot of Fourth Amendment case law. And so that was the reasoning why I said that I believe that a search or seizure was a different part of the search than entering in. Now, where it gets a little bit confusing is that, they can, if while entering the house, someone views something in plain view, they can seize that. But I think the officers who are doing the search would always secure the scene first and then go back and seize that. And so if the intent is that the person has to understand why they're being searched before the search occurs, then, I think your point is well taken, that if someone can't read and they're just handed a copy of the search warrant, they won't know what's going on. If the intent is at some point during the entire process, somebody should be given a copy and read it, then we can move around where in the process it is, or make it clear that, after securing the scene and prior to undertaking any search or seizure pursuant to search warrant, the executing officer shall read and give a copy. And so if you unpack the case law, I think that my point about the search being different from securing the scene is there. If you want to make it more clear, I'm sure we could come up with language to make it more clear that they are allowed to secure the scene prior to this requirement of reading and giving a copy of the search warrant.
Madam Chairman.
Yes, Delegate Watts.
As Council Mutnick was speaking, that exactly is the comfort level that I would like to have in the code. And therefore, again, having voted on the prevailing side, I would move that we reconsider the motion by which we removed the requirement to read, and I will offer a substitute motion that we begin the sentence with after securing the scene, so that there's no dispute about the officer's ability to secure the scene without having to read or give the warrant.
I would second that.
So we first
we have a motion to reconsider. That's been seconded. All in favor?
Aye.
Aye. Now, the new language amendment will read on line, council.
Madam Chair, on line 91, after search warrant period would read, after entering and securing the place to be searched and prior to undertaking, and then it continues on as written.
I so move.
Second.
Right.
Madam Chair, speaking to the measure.
All right, yes. Delegate Lindsay.
And I appreciate all the good work that has gone into the discussion, but I think that the end result of what's being proposed is to gut the measure in its entirety. Because what's being left out of the discussion is that in securing the scene, officers are not required to forget what they see, and in the sense of moving around and checking the premises to under the guise or under the pretext of making sure there's no one in a room or a closet or any area of the dwelling. They also are in essence searching. So all of what we're talking about to me is for naught, and what we're proposing guts the whole measure in terms of its original intent. And for that reason, I'm in opposition to the motion.
Thank you. And I think I said Delegate Mullins and Delegate Mullins.
Thank you, Madam Chair. I guess I've lost track of where we are in terms of the motions. Is this a motion that is acceptable to the patron, or is this something that the patron wishes that we not accept?
That was going to be my question, sir. Do you like that language? If it's fine, Delegate Aird.
Thank you, Madam Chair. I have to say that based on the description provided by Delegate Lindsay, the change would make me uncomfortable.
Madam Chair?
Yes.
We have to be clear that this is a case where they already have a search warrant to search the premises. So any action that they've taken while already in the house and seeing something in plain view is going to be something that they're going to be able to see because they already have a search warrant.
So this is my concern is that, and just correct me because I could be wrong, but you have a search warrant. As amendment, it sounds like securing the scene is sort of like you stay there. I'm going to secure the scene. And my concern is that an individual is not knowing of their why, sort of, and I don't know, maybe constitutional rights don't attach, but I would think that they have to be some sort of reading or given the warrant. If I'm wrong, I'm wrong, but that's my concern is that we're going to run into a constitutional problem.
Well, under current case law, they are allowed to enter the house and secure the scene before doing anything else, because the court has said that they are allowed to do that in order for officer safety and for securing any, keeping the destruction of evidence from occurring. And so that's current law that they are allowed to go in there and do that. What this is saying to me, especially with the amendment, because it's even more clear, is that after they do that initial, we've got a search warrant, and without the no-knock, they have to knock and announce. So they have to say, knock, 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 police. And under the case law, the Supreme Court case law, they have to give somebody an opportunity to come to the door. And so knock and announce. So the way this works would be a knock, 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 police, search warrant in the house. You stay there, go through, make sure there's nobody else in the house, come back. We have a search warrant. I'm going to read you the search warrant. We're searching for the violation of this law. We're going to now search the house. That's how I think this works. And Delegate Lindsay is right in that while they're doing that clear, they can say, oh, I see a gun over there or I see drugs over there. But those were going to be discovered anyway by virtue of the fact that they have a search warrant. This is not a case where they are coming in prior to obtaining the search warrant under this statute and searching and doing a secure of the scene and seeing things in plain view at that point.
Hey, Delegate Mullen.
Thank you, Madam Chair. I guess I'm trying to clarify for all of our minds exigent circumstances versus circumstances in which there are a warrant has attached. So in the cases in which there are exigent circumstances, the likes of which that Delegate Heretic and Delegate Lindsay have brought up of a hostage situation or potential destruction of evidence, exigent circumstances, would those still apply, or would those be limited by this bill? And I guess that's more a question to the ether than anything else. Perhaps Mr. Mutnick, Ms. May, but probably to the world at large.
Madam Chair?
Yes.
In this case, this statute would not apply in any way to a situation where a law enforcement officer comes upon a place and has exigent circumstances to enter without a warrant. So none of these requirements would apply in that case. And so this is a case where you have gotten a warrant and you go serve it. And so you have to keep those two separate. There's no exigent circumstances in these cases. If there were exigent circumstances, then they wouldn't need to get the warrant and none of this would apply in the first place.
So, Madam
Yes.
Chair.
Yes, Delegate Mullen, and then.
So I guess building off of Council has elucidated for us, we're talking about a very limited set of circumstances under which there is something that is not exigent, but also could be something the subject of a warrant. And so I guess I'm wondering whether or not we are asking how many angels we can sit on the head of a pin in terms of where we're going with this. We have demonstrable circumstances where a exigent circumstance occurs, and that is life and safety of a member of the public or of law enforcement. That is always going to be something in which law enforcement can act. Then we also have exigent circumstances for the immediate destruction of evidence, which is also something that has been labeled under Fourth Amendment case law. So what we're talking about are the circumstances in which those two do not apply, and yet we still want to seek a warrant that involves no knock. And so I guess there are many circumstances in which we could come up with some far-flung idea, but the reality of this is that 90% of the time this is someone that we're worried is going to flush the cocaine down the toilet, and we would already be able to make a no-knock anyway. So I guess in this as a question or speaking to the bill.
Well, hold on. Are you speaking to the bill? Because we have other people.
No.
We haven't decided on the amendment.
You had a question. So Delegate Eric responded. So I'll come back to you, Delegate Mullen. Delegate Simon.
Yeah, Madam Chairman. So
Yes.
Delegate Mutnick described this process, right, where you do the knock, 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 police, I have a warrant. They come in, and then they secure the scene. Then they actually say, here's a copy of, and read the warrant. How is that different than current law? And also, how is that different with or without the amendment that's before us?
Madam Chair, yeah, 4.5 years I finally got promoted. Delegate Simon, it really isn't any different. I mean, what this statute is doing is this is saying that you cannot serve a warrant without knocking and announcing. Under the current, under Supreme Court precedent and Virginia Supreme Court precedent, there are certain circumstances before or right now where somebody could serve a search warrant without knocking and announcing. I thought it was interesting that there hasn't actually been a case on it since about the year 2000. And so it's something that doesn't happen very often, as they said, but this statute doesn't change how a warrant is served under normal circumstances. All it just says is that they have to knock and announce. What the language on line 91 does is that does add an additional, you have to read the warrant to the person. And so what we're talking about is that when during the service of this warrant is that done? And I read even the language that it is under current language, the initial bill, that it's done after the police have secured the scene, but before they do their search, they have to read it. The amendment just makes that more clear that after the police have entered the home based on the lawfully obtained search warrant, secured the scene so that they may conduct their search safely, before they start opening drawers and opening doors and going through people's things, they have to read and give a copy of the warrant to the person, the owner of the place to be searched, or the person who's there. And so it really is just that is the only real new thing in how warrants are served, is that they have to read it. And it's really just all about the timing of that is, and I really think it makes it untenable for the police to have to come in, knock on the door, say search warrant, and then stand there while people are running around and read them a copy of the search warrant. Because if you've seen search warrants, some of them are very long. And so I think that the reason that the Supreme Court case law exists to say that they can enter and secure first is so that it's done in a safe manner for everybody. And there isn't anybody jumping out of closets or doing that, or back in the bathroom flushing things down the toilet while they're talking to the occupants. And so really 991 is just the only addition that says that prior to the search being done, you have to read this. And I think that the amendment makes it so that it is clear that it happens after you've secured the scene, but before you search.
Right.
Madam Speaker.
Yes. And actually I have Delegate Scott, Delegate Sullivan, and Delegate Campbell in the queue on this is speaking to the amendment, correct? Delegates.
Madam Speaker. Madam Speaker?
Yes, Delegate Scott.
As I look at it and I was listening to the amendment, I mean, I'm speaking to the amendment in the construction in this area. Everybody knows what this bill is trying to get to. It's trying to prevent no-knock warrants whereby something that happened to Breonna Taylor wouldn't happen to anybody else. Folks want to be in their sleep and wake up with the police in the wrong home and murder them. This bill, the way it's written now, I would just say on line 88, it clearly says no law enforcement officer shall seek, execute, or participate in execution of a no-knock search warrant. And all of the other stuff kind of starts adding different language that is already kind of defined in our Fourth Amendment case law, and starts adding some other things in there, as well as on line 97 where it excludes anything that's found. So I'm interested to hear what counsel would say. Why doesn't the solution, the problem that Delegate Aird is trying to solve, why is it not solved with a period after warrant on line 89?
Mr. Munich?
Madam Chairman, I think that Delegate Scott's point is well made, but I would go to the end of line 91 to do what he is trying to do there. But yeah, I agree that if the intent of the bill is just to outlaw no-knock warrants, the other part of it is sort of a codification of what's existing about people having notice of their searching. The current law is only that it is left, that a copy of the warrant is left at the place after the search occurred. And so this would change current law and make it more open about what is being searched. But yeah, the point to have it outlaw no-knock warrants after the period on line 91 would take care of that.
All right, so we'll still, I'm going to continue with, this is on the amendment before us because I have a feeling there's going to be a substitute. Delegate Sullivan.
Madam Chair, I'd actually taken my hand down, but just confirming what Delegate Mutinick just said.
Yes.
There's currently no Fourth Amendment law, statutory or case law, that requires a search warrant to be read to anybody. It's not like they have, once they understand what's happening, some opportunity to object. So I just think we're really getting wrapped around the axle here over this read to them issue. And I don't know why we're creating new requirements. So I'll yield.
I have Delegate Campbell and Delegate Mullen.
Yes, Madam Chairman, I think after I made my comments, we got a little bit out of kilter here. And search warrants can be issued for evidence or persons. So if you have an arrest warrant, you can obtain a search warrant to go into a house to get the person. Now, it gets really confusing when you have to try to serve a warrant, because you can go beat on the door all day long, and if you don't have a search warrant, you can't get in the house. You may know he's in there, but you don't have proof that he is, so you just can't go in there. And that's what I was talking about. In these situations to where the police have a person that they have an arrest warrant for, this person they know for a fact is going to try to cause harm to them, then we shouldn't limit this option for police, because it's going to cost more police lives if we do.
Right, and then I think of Delegate Mullen, then we still have a sort of amendment before us.
Madam Chair, we've had a robust discussion about all of this, and we have heard from all sides, and so at this time I would have a motion if that's appropriate.
Yes, I want to hear from Delegate Bourne. I'm sorry, he had his hand up, and then I'll go back to you, Delegate Mullen, and then.
Yes, Madam Chair.
Yes, Madam Chair. Just a quick question for the delegate. There's been, I think, the most recent suggestion that seems to be gaining some momentum is what Delegate Scott said, followed up by what Council said. And so just wanted to get Delegate Aird's sort of reaction to that.
Thank you so much, Delegate Bourne, and thank you so much, Madam Chair and members of the committee for the discussion. I appreciate the comments made, and if I'm following correctly, I want to just respond to why this additional language is being spelled out. To me, based on the conversations I've had with people who have been impacted, I felt the best approach would be to not only ban the use of the no-knock warrants, but make clear what someone who is being, the individuals who are being served, to be clear about what they are entitled to, which is what that additional language is. And so it is my hope that we would not eliminate that language. I hope that that clarifies where I am and why this language is listed in that way.
Thank you, Delegate Aird. Delegate Mullen, did you still have a motion?
Yes, Madam Chair. At this point, I would move the pending question.
So, Council, if you can just read the pending question. I know it was an amendment.
It was an amendment on line 91 that would be at the end of the first sentence, would say, and I need to go back to my notes here and find the exact language. After entering and securing the place to be searched, and then to the current language of and prior to undertaking any search.
Right.
That was the last amendment offered.
Right. There's a motion on the amendment. Is there a second? Right. The motion dies for lack of a second. So we had the bill before us again. Yes, Delegate Watts, I'm sorry.
I'm sorry. I thought
Yes,
there
ma'am.
had been a second to my amendment.
Oh.
What you were calling for was a second to the motion that made by Delegate Mullen to call off debate. If I am wrong, I do apologize.
No, that's all right. No, thank you for keeping it straight. So he called the question, and the question was on the amendment. So all in favor of the amendment? Yes, Delegate Watts, am I still?
No, that's right.
Madam Chair,
Yes.
I a second.
Yes, Delegate Mullen.
I apologize. I'm gotten so lost in the minutia of all of this. The current motion as it exists, is this something that is acceptable to the patron? Just so that we can clarify where we are procedurally.
So Delegate Aird, is that amendment okay with you?
I have to be honest and say I'm trying to keep track with which language specific smaller, because I had a note here that we were talking about after securing the scene, but that did not sound like what was just read, so I'm a little confused.
Can Mr. Munich read it again one more time?
Madam Chair, it's
yes.
after entering and securing the place to be searched.
What line are you on?
Line 91, after the words search warrant period, but before prior, we would enter the words after entering and securing the place to be searched.
Madam Chairman, since
yes.
we have not
Delegate Watts.
Called the question, if I could speak to the motion as I have listened intently to all of this input.
Yes, Delegate.
Essentially,
Chairman,
doing here
the motion to move the pending question, that's not debatable.
Wait, hold on. Delegate Simon, Delegate.
Is there a motion to move the pending question? Because that's not debatable.
All right, you know what? I have the gavel. I'm going to give Delegate Watts, if I'm out of order, then, I mean, I'm sorry, but Delegate Watts has the floor. Delegate Watts.
My apologies to the parliamentarian, but I did not say anything until others had been recognized. Repeating, since the discussion that we have had has underscored that what essentially we are doing is simply codifying case law on the Fourth Amendment, with the exception of the requirement to read. We run the risk of, if we codify everything else and we don't qualify what we mean by reading and when, since there's no case law comparable to all of the other language, I think that we open up a major problem that's just unnecessary. That we might as well codify this aspect as well, and that is the case law on being able to secure the scene.
All right, so.
Madam Chair, I don't believe Delegate Aird ever responded to whether she reviews this now as a friendly amendment or not.
Has the question been called or not?
All right. So I know it's getting late, but this is very important. So right now, I want to hear from the presenter of the bill. This is very serious, and I'm not going to rush through this for anybody. I got stuff to do tonight, just like everybody else.
Madam Chair, I withdraw.
Wait, hold on.
So that she.
Delegate Aird there was a question about how she feels about this. We are not rushing this. We're going to get it right. Delegate Aird.
Madam Chair and members of the committee, I am okay with the change.
Yes, Delegate Aird, I didn't hear you.
Can you hear me now?
Yes, ma'am.
I said I am okay with the recommended change.
Right, thank you. So there was a motion to adopt the amendment. All in favor?
Aye.
Aye.
Any opposed? All right. The amended bill is before us. What is the pleasure of the committee?
Move to report as amended.
Second.
It's been moved to report it as amended. Let me just check my sheet. Right, it does not have to go to appropriation. So move to report with the amendment. All those in favor, please indicate your vote on the electronic voting board. right? The bill reports 12-8. Thank you, Delegate Aird.
Thank you, Madam Chair and members of the committee for all of your time.
Thank you.